Stuart McMillan on behalf of the Delegated Powers and Law Reform Committee.
Thank you very much, Presiding Officer. First of all, I'd like to highlight just one of the responsibilities of the Delegated Powers and Law Reform Committee is to scrutinise Scottish Law Commission bills. And these bills can often be perceived as being quite technical, and members may think that our scrutiny is consequentially quite dull and technical. But the bills that the past committees have looked at, and also the one in front of us today, the Moveable Transactions Scotland Bill, are interesting and hugely important pieces of legislation. Without getting into too much of the technical detail, the bill will reform two elements of law on movable property. That is property such as cars, machinery and whisky barrels, to name just three examples. It will reform the assignation of claims and also the law of pledges. Assignation of claims simply means the transfer of a claim from one person to another, usually the right of payment of a debt. And a pledge is a type of security, usually for a loan, which is taken over movable property and works in a similar way to a mortgage on a house. Under the current law, an assignation can only be completed by letting the person who owns the debt know about it, about the assignation, which is known as intimation. A pledge can only be granted under the current law by delivering the property that has been pledged to the person granting the loan. Now, this bill changes this by creating two new registers, as the Minister touched upon, the Register of Assignations and also the Register of Statutory Pledges. The bill will enable the registers to be used to grant assignations of claims as an alternative to intimating the assignation to the debtor and to grant statutory pledges over movable property. There was almost universal support among the business community for the reforms proposed in the bill. And the committee heard that the current legal infrastructure was from the 19th century and that reform in this area was needed drastically and as quickly as possible. Others noted that Scots law was behind the law in many other jurisdictions, and this area and the English law would sometimes actually be used rather than Scots law due to current barriers. Now, I attended the CBI event in the Scottish Parliament last week, and one of the guests at the event indicated to me that the organisation that they work for will be using, if providing this bill obviously passes through the Parliament and becomes law, they will be using this piece of legislation on day one. Now, that can only be a good thing for the Scottish economy, because it will actually keep money in Scotland's economy. Now, we heard about the current requirements for intimation, which could be cumbersome and costly, and the complex trust arrangements which are used to get around the current legal requirements. We also heard of the difficulties for businesses because of the requirement to physically be in possession of the pledged item. Witnesses told us that if implemented effectively, the legislation would provide significant benefit to the Scottish economy, allowing more finance to be provided to more Scottish businesses through a wider range of finance options. The Federation of Small Businesses in Scotland told the committee that the most common forms of finance that have been acquired by small businesses in recent years were overdraft facilities, credit cards and asset finance, and that while the bill could be seen as being technical, it could have a significant impact on the financing options available to the small business sector as well. However, while there was support for the introduction of the registration of a statutory pledge amongst the business community, there were concerns about the impact of the reforms on individual consumers. And with that, I note the comments from the Minister in his opening comments, and I'm sure that colleagues certainly within the committee will certainly welcome the comments from the Minister. So thank you for that. Sure.
Martin Whitfield.
I'm very grateful to Stuart McMillan giving way on that point. Did the committee have an opportunity to consider how individuals can be removed from the bill, given actually the sole trader position and indeed small partnership position, where they are in effect individuals in law?
Stuart McMillan.
This certainly was something that came up in evidence, and the committee members, when we were discussing this, it was clear that this would be complicated to actually try to manage. And certainly with the Stage 1 report, with the recommendation that we made in the report, we did acknowledge that that actually would be difficult and challenging. And I think the comments from the Minister earlier on acknowledged that too. But certainly, obviously, any amendments that will come forward will be scrutinised in great depth by the committee, as I'm sure the member would appreciate. But certainly that acknowledgement was very much there. So, as a result Advice organisations were united in their call for consumers to be excluded from the reforms in the bill relating to statutory pledge as the best way to protect consumer interests. And I note certainly the letter that the Minister has sent to the committee in this regard, and obviously we as a committee we did highlight the issues regarding consultation, which I'm going to come on to shortly, the issue of consultation after the SLC do produce their bill, and then obviously that further engagement with the consumer credit organisations. I think it's fair to say that the committee received conflicting evidence on the risks to consumers of the proposed reforms and the extent to which protections in the bill were actually adequate. However, there were also conflicting views on the extent to which individual consumers granting a statutory pledge would be protected by the Consumer Credit Act 1974 and also the current Financial Conduct Authority regulations. But ultimately, the fact that the committee recommended that individuals not acting in a business context should be excluded from this part of the bill. Something that we've already touched upon. The committee also recommended further changes to the bill to increase protection for consumers in the event that they were not excluded from the bill, including increasing the threshold of an asset that could be granted as a pledge from £1,000 and recommending that the bill should be amended to specify that essential household goods are excluded from the items that could be pledged. The committee also heard evidence about how the registers would operate in practice, including the fees that would be charged for accessing them. Now, one concern raised was that the registers might contain inaccurate information if they weren't updated regularly. As a result, the committee recommended that the bill is amended to require certain updates to be made to the registers timely or within a specific time frame, such as assignation or, in particular, the discharge of a pledge. We noted that a lot of the detail about the operation of the registers would be contained in regulations, and we stressed the importance of oversight of the draft regulations, as the Chamber will be very much aware. With this particular bill, the Delegated Powers and Law Reform Committee has got two functions. One, the policy, which is unusual for our committee, but secondly, the usual part, which is about looking at the regulations and secondary legislation. One final issue that I wanted to cover is an element of the original draft bill from the Scottish Law Commission that doesn't appear in the bill considered by the committee. This bill doesn't include the assignation of claims over financial instruments such as shares and bonds. In the policy memorandum, the Scottish Government indicated its view that these arrangements were beyond the legislative competence of the Scottish Parliament. Instead, the Scottish Government has indicated that it has asked the UK Government to grant an order under Section 104 of the Scotland Act 1998, and the order would have the same effect as if the provisions had been actually included in the bill, and would therefore complete the full extent of the reforms recommended by the SLC. Stakeholders stressed the importance of the reforms applying to shares, and that the requirement to take ownership of shares and the responsibilities that can come from this is a major barrier to Scottish businesses using them as security. There were calls for the financial instrument reforms to be progressed with great urgency, and the committee are very much aware of there has been regular correspondence between both Scottish and UK governments to try to have this matter resolved. We know that the Scottish and UK governments are currently also having those discussions, but we do certainly we still do urge both governments to resolve the question of whether a Section 104 order is required. If it is concluded by both governments that such an order is required, the committee recommends that the Scottish Government pursue this with the UK Government as a priority. And before I close, can I thank all those who have contributed to the committee's scrutiny of the bill, whether in writing or by appearing before the committee during one of our evidence sessions. As members know, the committee's scrutiny is only as good as the evidence that it actually receives, and so we genuinely are very grateful for the time and energy given to help the committee in its work. I also want to thank fellow committee members for their scrutiny and for our excellent clerking and legal team for their assistance. I want to thank the Minister and his officials for the evidence that they provided to the committee and for the Scottish Law Commission for proposing the bill. The committee did note that the significant concerns from the consumer and money advice organisations about the bill's proposals have only been identified at the stage of parliamentary scrutiny. Now, the letter from the Minister seems to indicate something different with that. But we therefore recommend that when the Scottish Government is considering introducing a bill to give effect to an SLC report, and significant time has passed since the SLC's original consultation on its proposals, further consultation should be taken. But I'm sure that will be very much the discussion that will continue beyond today, certainly for between the Scottish Government, but also the consumer organisations. But as a committee, we are clear that the bill is proposing important reforms which will benefit businesses across Scotland, and that they are likely to have a beneficial impact on access to credit and finance. And nonetheless, there are important issues to consider regarding the impact of these reforms on individual consumers and how they can best be protected. We do look forward to working with the Scottish Government on the issues in advance of Stage 2. And with that, I certainly recommend and commend the Stage 1 report to the Chamber. Thank you.